Should someone represent themselves in court? It is unfortunately a hard no with a big but. And no, I'm not putting that on merch. Viva Frei, Montreal litigator turned YouTuber. I do these things called vlogs, and for the longest time people have been asking me what I think about self-representation. Should people represent themselves in court, and if they do, what advice might I have to give them? It's a tough question, and oftentimes it's not really a decision that is taken out of free will, it is a decision that is taken out of necessity. Should someone represent themselves in court? To the extent that they have the financial capabilities of hiring an attorney, obviously they should, and I will get into why later. Ultimately, above and beyond the very rare cases where someone actually has the means, the finances, the ability to hire an attorney and decides to represent themselves, in the vast majority of situations there are only really 3 or 4 reasons why people end up representing themselves. First and foremost,
economics.
Lawyers are not cheap. Even affordable lawyers are not cheap. I consider myself to be among the most affordable lawyers anyone will ever find anywhere, and even I don't have the means to pay myself for representation. It's not to be crass or insensitive about money, but $250 an hour for a quality attorney is nothing by industry standards. You can and will pay easily upwards of $300 to $500 an hour for a standard attorney with 10 to 20 years experience. High-profile criminal attorneys, top civil litigators, tax attorneys, you could easily be spending over $1,000 an hour. But oftentimes people just don't have the means to hire an attorney, and they don't necessarily fit the criteria for legal aid. And so people are stuck between a rock and a hard place. Do they hire an attorney knowing they're going to have problems paying that attorney? Do you find an attorney who's going to take the file on a flat rate basis, which unfortunately but oftentimes means that after they've put in a certain number of hours, their interest in the file starts to dwindle because it becomes sort of a game of diminishing returns. $5,000 for a 10-hour file is great, but when that file starts taking 20, 30, 40, 50 plus hours, some attorneys might start losing interest, putting in less work, putting in half-hearted work because they're simply not getting the return that they wanted. And I don't mean to be cynical or disrespectful to the attorney. People are entitled to get paid for the work that they do, and everybody is trying to survive, and it is only natural that if you have a file that is actually paying $300 an hour versus the $5,000 flat fee, now you're entering your 75th hour, it is only natural that a lawyer might prioritize the file that actually pays the bills. Do you try to find a lawyer who's going to take a file on contingency? And this is definitely much more frequent in terms of plaintiff lawsuits in the United States, but it's a lot less frequent in Canada and even more so in Quebec. In Canada and even more so in Quebec, we don't have these massive, obscene payouts for bodily injury. We no longer have the traditional and stereotypical ambulance chaser of lawyers who track down victims of car accidents, because in Canada we have a law that governs the compensation that can go to victims of car accidents. And the other reality is that even in highly litigious societies where the payouts on lawsuits is sometimes obscene, you don't have contingency work for defense work because you don't get paid a sum of money for successfully defending against a lawsuit. So if you are stuck having to defend against a lawsuit, you're really not going to be able to find a defense attorney who's going to take that file on contingency. Hiring a lawyer is notoriously costly, even with the affordable ones. That is the first reason why the vast majority of people represent themselves in court out of financial necessity. Another reason why people end up representing themselves, and this leads to certain other problems with the representation, and we'll get into it in a bit, oftentimes it is a question of mental health wellness. Sometimes people are just unable to find representation. They've already gone through multiple lawyers, and so no new lawyer is going to take the file knowing that they would be the 4th, 5th, or even 6th lawyer in the file. Another reason, although far less frequent, is that no lawyer will touch the file. There may be politics at play that make other lawyers very reluctant to jump into the file, and sometimes a client is just unwilling to accept the advice or follow the recommendations of any lawyer they approach to take the file, such that no lawyer ends up taking the file. This reason is far less frequent because I say this sort of cynically, but for the right price, you will pretty much be guaranteed to find a lawyer who will represent you in any file. And so that's it. Pretty much when people end up representing themselves, typically it is out of necessity and not out of free will. If you have the choice, why should you not represent yourself? There are a number of reasons. Let's just start with a hypothetical anecdote from some lawyer's life. Let's call him Mr. Orange. Mr. Orange receives an email from Mr. Black. Mr. Black, in his email to Mr. Orange, lays out a bunch of personal accusations, mischaracterizes the file, and hurls a bunch of insults. Mr. Orange, employing all of his skills with language, drafts the most biting, crushing rebuttal, setting the record straight, setting the lawyer straight, hits reply all, and hits send. Mr. Black responds to Mr. Orange with an email to the effect that,
"You violated your code of ethics by corresponding with my client."
Mr. Orange says, "What are you talking about?" and goes and looks back at the email and notices that Mr. Black had put his own client in CC to his email to Mr. Orange. Now, in this hypothetical jurisdiction, it is against the attorney's code of ethics to knowingly communicate directly with a client whom he knows to be represented. Mr. Orange gets, let's just say, extremely frustrated and believes believes that this might have actually been a setup. But Mr. Orange, knowing that you don't reply angry, seeks the advice from another attorney, Mr. Pink. And Mr. Pink says, whoa, Mr. Orange, let me deal with this. This is a non-issue. You're overreacting, and we'll resolve it. And it gets resolved. But what does this purely hypothetical situation illustrate other than the fact that lawyers can sometimes be the scum of the earth? I'm sorry, that's not nice. That's not nice. Other than the fact that lawyers sometimes play sneaky games that confirm every stereotype anyone has ever had against attorneys. I did it again. I'm sorry. This perfectly illustrates why doctors are not supposed to diagnose and treat themselves. Why shouldn't someone represent themselves? It is sometimes very difficult to dissociate their personal emotions in the file from the file itself. If you're emotionally involved, it will affect your judgment.
Period.
Imagine a doctor trying to operate on themselves, trying to make an incision in their stomach. They would be so blinded with agony that they would not know what they're doing. If they gave themselves the required painkillers, they would not be mentally there to know what to do. Even assuming they felt no pain at all, they would not have the right angle to see down as to what they needed to do. Compare that to someone who's looking over the body, who is clear of mind and emotionally detached from what is going on, has the perfect vantage point to see, assess, and determine what needs to be done, and the perfect mental wherewithal in order to do it. This analogy applies perfectly to law, except the pain is emotional and not physical. Law is pain. It is hardships. Financial, personal, emotional. Litigation is pain. Anybody who says otherwise is trying to sell you something.
Life is pain, Highness. Anyone who says differently is selling something.
And when you're in pain, you don't necessarily react properly. You don't necessarily make the best decisions. When you're in pain, you are viewing the situation from that of someone who is in pain and not from someone who sees it from a distance objectively. That is why everyone should have an attorney, for them to be the eyes of objectivity and not be tainted by emotional distress. And people generally have this oversimplified misconception of the practice of law and lawyers, that lawyers are necessarily biased, they're partial, they do everything their clients say, etc., etc. This may be true vis-a-vis the opposing party, but vis-a-vis their client, they have to remain objective. They have to remain neutral to the extent that they are giving their clients the best, most independent, proper legal advice possible. And it's an observable tendency from the practice. When lawyers become emotionally invested in their files or in their clients, it changes their behavior. It affects their judgment and it affects their conduct in the file. To get proper representation, it requires the proper distance from the file. It is a distance that the person themselves will never have in the file vis-a-vis themselves. Another obvious reason why someone should not represent themselves is they don't necessarily know the law as well as lawyers do who are trained in the matter. And this admittedly is changing with the advent of the internet, because oftentimes now people end up with clients who actually know more about the law and their particular case than the lawyer. But knowing the law is one thing, knowing the procedure is another, knowing how to work within the court system is something entirely different. And for right or for wrong, the court system views self-represented individuals differently than they view attorneys. Judges have to deal with attorneys day in and day out. They have to deal with attorneys knowing full well what the vast majority of attorneys are like in real life and in the practice. Judges are already tired, overworked, impatient. They are constantly on the lookout for the shenanigans that lawyers play on other lawyers and on the court itself. And they are even more on the lookout for this when the individual is a self-represented individual. They are on the lookout for this because the reality is, within the court system, the self-represented clients typically are the ones going through the hardships I described earlier. And so judges view the self-represented client somewhat differently. They might give them more leniency at times, but they might also be more impatient with them at others. Attorneys view self-represented individuals differently, for good and for bad. Attorneys know that the self-represented individual are not paying legal fees, which sort of changes the nature of the game vis-a-vis the parties. On the other hand, the attorneys know that self-represented individuals might fall into certain traps. They might be easier to antagonize. They might be easier to instigate into some sort of aggression. They might be easier to pick on, and they might be easier to dupe. And the other reality as far as self-represented clients go, knowing the law is sort of a double-edged sword. I can tell you from my own practice that what oftentimes ends up happening is the self-represented client might know the law and the procedure better than most lawyers. They might know it so well that they can start fights over procedural irregularities multiple times a day. But knowing the law is different than knowing the strategy. Knowing the law is different than knowing which battles to pick. And the problem with self-represented litigants is that they may know the law, and being so emotionally invested in the file, every battle for them is a tooth and nail battle. Every battle is equally as important. Every battle is life or death, whereas to a judge it might not necessarily be that case. And there is a reason why self-represented litigants are disproportionately the litigants that are declared quarrelsome litigants, vexatious pleaders. The ones who have filed an excessive amount of lawsuits, an excessive amount of motions, have made pleadings that are totally over the top, even if they are procedurally justified. And there are obvious reasons for that. They don't have an attorney to talk them down out of fighting every battle as though it's the last battle. They don't have an attorney to temper their reflexive reactions. They don't have an attorney to tell them that this might not be the hill to die on. And so what ends up happening is they file an excessive amount of pleadings, even if there might be some procedural justification, and a judge says, this is enough, you are bogging down the legal system with these multiple pleadings, you are no longer filing any pleadings without the authorization of the court, and by that point in time, the party has effectively discredited themselves in the legal system. A while back, I made a video called A Musical Metaphor, and the idea was that that basically you can play the same two notes over and over and over again and change nothing but the underlying chords, and those same two exact notes played in the exact same way are going to sound different depending on the underlying chord structure. And I'll show you a clip from that video right now. Incidentally, everyone loved the Wayne's World reference in one of my other videos, so I'm going to do it again. I'm going to show you something on the piano which is actually a metaphor for life. I'm going to play two notes. I hear somebody.
Who are you talking to?
My camera. Just going to play the same two notes with different notes with the left hand to show you how the sound of the two same notes will change depending on the context or the underlying notes with the left hand. The metaphor is that notes, depending on the context, even if they're the same notes, will sound different. The notes are facts. The underlying context is how you view the world. It's in Revelations, people! And that is to say that when a self-represented litigant does the exact same thing as an attorney, that very same act is going to be viewed differently by the court depending on who did it. And again, this is a double-edged sword to some extent because sometimes a self-represented litigant might get away with something because an attorney should know better, whereas a self-represented litigant might not know better. But for right or for wrong, it's just the nature of the beast. A judge will give the benefit of the doubt, will give greater credence to an act carried out by a lawyer, a member of a professional order who went through 4 years of law school, etc., than they will to a self-represented litigant who might do the exact same thing. Alright, and that is the end of the negative side of this video, why people should not represent themselves. Let's end it with a positive note because sometimes people do not have the choice. If you are in fact compelled or have just chosen to represent yourself, what pieces of advice would I have? Number one, oftentimes you will not be able to dissociate your own emotional distress from the situation. That said, when interacting with the court staff, be courteous, be polite. If they don't like you when the court closes at 4:30, it doesn't matter if you were there at 4:31, the gate is closed, come back tomorrow. If you have been nice, polite, and respectful to them in the past, and you show up at 4:32, they might open the door a little crack and give you the answer that you need. As difficult and borderline impossible as it will be, do not personalize the process. This is another one of the risks of being self-represented, is that you don't have that buffer between you and the suit. You don't have the lawyer to sort of take the hits for you and diffuse the impact. You are taking the gut shots directly day in, day out. And it may be impossible to do in reality, but don't take everything personally, and do not personalize the litigation with the opposing lawyer, with the judge, or with the court system in general. As difficult as it may be to accept, it is what it is, and it is the nature of the beast.
It's not personal, it's law.
Although oftentimes it is in fact personal, but you need to separate your emotions from the situation in order to know how to govern yourself accordingly. Pick your battles. It's not because you're right that the court is going to care. The court does not want any party running to the court every time there is a disagreement. They don't want people running to the court with motions every time there is the slightest issue in the file. Lawyers can typically appreciate this, whereas with self-represented litigants, every question is a question of principle. It is a question of principle. They want the judge to tell them that they were right and that the other lawyer was wrong, and they end up in court more often than they should. And that irritates judges, and that causes judges to question the judgment of the party who keeps running to court over each and every little tiff. Be respectful, be courteous, smile, give everyone the benefit of the doubt, kill them with kindness. It sounds ridiculous and it is oftentimes very difficult to do, but it was one of the best pieces of advice that a certain much older lawyer gave me, which has always stuck with me. The best lawyers always manage to make their clients out to look like the victims. And the risk about being a self-represented litigant is that even if the self-represented litigant is in fact the victim, oftentimes they end up coming off as the victimizer. They end up coming off as angry, belligerent, and extremely litigious. Filing multiple motions, not being courteous with opposing counsel, cutting off the opposing party, not respecting the decorum of the courtroom. It's not uncommon that the victim, in responding and reacting to their victimhood, becomes the victimizer. And when that happens, they lose credibility and they lose standing before the court. And it is oftentimes extremely difficult to examine the opposing party without coming off as the aggressor. Because oftentimes, and understandably so, the emotions run high, but the emotions end up taking over. It only takes one outburst of a self-represented client to lose all standing before the court. Alright, and you know what? The more I say this, the more I realize that this advice actually doesn't only apply to self-represented litigants, it ought to apply pretty much to all lawyers. That is pretty much it. I think we have covered all the bases. I hope that answers your questions. If anybody has any questions, put them in the comment section below and I will do my very best to get to them. One thing I'm not particularly good at, that I've never been particularly good at is asking for support. If you like my videos and you like this content, like, share, subscribe, share my channel, share my videos, tweet them at someone who you think would like them. If you want to support the channel, there's a PayPal option up in the banner of the channel. I'll put the link in the comment section below. If you want some merch, you can always support the channel with some merch. Anybody who gets some merch, take a picture, post it on social media, and tag me. I love seeing people wear these shirts. And with the gentle rustling of the corn, I say, now you know your vlog. Peace out. Booyah!